The House Committee on Corrections will come to order. The clerk will call the roll.
Representative Murr,
Here.
Representative Allen,
Here.
Representative Rodriguez, Representative Martinez Fisher,
Here.
Representative White,
Here.
Representative Burrows,
Here.
Representative Bales,
Here.
Representative Sherman, Representative Slayton.
Here.
A quorum is present, and we'll acknowledge that Representative Martinez Fisher is participating virtually this morning. Thank you to all members and guests for being here today, especially for those of you who have traveled from out of town. We appreciate your taking the effort to do that. Before we move any further, we're going to take up some pending business on some bills that we've previously heard, and then we'll move on to the bills before us today. Before you testify, we ask all witnesses to give your name, your position on the bill, and who you represent for the record. All witnesses must also complete the witness affirmation form accessed at the kiosk in the hallway if you haven't already done so. The assistant committee clerk can assist you with that process or any questions if you may have them. Also want to note that some of our committee members will be coming and going this morning. That means that they are also serving on other committees or that they have bills to lay out in other committees. And so please note that your testimony is important to us. We do take a lot of notes and our staff helps us with that. Depending on time, we may also limit testimony to 2 or 3 minutes. We'll have a timer with lights and beepers to help us facilitate moving folks along expeditiously. Members, any questions or comments before we begin? And the chair will acknowledge and let the record reflect that Representative Sherman has joined us. Mr. Sherman, we're just about to take up pending business and vote a few bills. So the chair lays out House Bill 721 as pending business. Members, this is a bill that we heard last week by Representative Wilson relating to the release of supervision for certain inmates confined in a county jail. Representative Burrows moves that House Bill 721 without amendment be reported favorably to the full House with a recommendation that it do pass be printed and sent to local and consent calendar. The clerk will call the roll.
Representative Murr,
Aye.
Representative Allen,
Aye.
Representative Rodriguez, Representative Martinez Fisher, Representative White,
Aye.
Representative Burrows,
Aye.
Representative Bales,
Aye.
Representative Sherman,
Aye.
Representative Slayton.
Yes.
There being 7 ayes and no nays, the motion prevails. The chair lays out House Bill 2036 as pending business. Members, this is a bill we heard last week by Representative Johnson relating to the definition of a close relative of a deceased victim for purposes of certain laws relating to the release of an inmate on parole or to mandatory supervision. Representative Allen moves that House Bill 2036 be without amendment be reported favorably to the full House with a recommendation that it do pass and be printed and sent to local and consent calendar. The clerk will call the roll.
Representative Murr,
Aye.
Representative Allen,
Aye.
Representative Rodriguez, Representative Martinez Fisher, Representative White,
Aye.
Representative Burrows,
Aye.
Representative Bales,
Aye.
Representative Sherman,
Aye.
Representative Slayton.
Yes.
There being 7 ayes and no nays, the motion prevails. The chair lays out House Bill 2331 as pending business. Members, this is a bill we heard last week by Representative Cortez relating to procedures governing declared disasters for the Texas Department of Criminal Justice and the Board of Pardons and Paroles. Members, there is a committee substitute for this bill. At this time, the chair lays out the committee substitute for House Bill 2331. Is there any objection to the adoption of the committee substitute? Chair hears none, and the substitute is adopted. The chair moves that House Bill 2331 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed and sent to the general calendar. The clerk will call the roll.
Representative Murr,
Aye.
Representative Allen,
Aye.
Representative Rodriguez, Representative Martinez Fisher, Representative White,
Nay.
Representative Burrows,
Aye.
Representative Bales,
Aye.
Representative Sherman?
Aye.
Representative Slayton?
Yes.
6.
There being 6 ayes and 1 nay, the motion prevails. The chair lays out House Bill 3621 as pending business. Members, this is a bill we heard last week by Representative Cortez relating to the creation of a mental health jail diversion pilot program in Bexar County. Members, there is a committee substitute for this bill. At this time, the chair lays out the substitute for House Bill 3621. Is there any objection to the adoption of the committee substitute? The chair hears none. The substitute is adopted. Representative Sherman moves that House Bill 3621 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed and sent to local and consent calendars. The clerk will call the roll.
Representative Murr?
Aye.
Representative Allen?
Aye.
Representative Rodriguez? Representative Martinez Fisher? Representative White?
Aye.
Representative Burrows?
Aye.
Representative Bales?
Aye.
Representative Sherman?
Aye.
Representative Slayton?
Yes.
There being 7 ayes and no nays, the motion prevails. Members, we will have some other pending business to attend to, and we'll probably do that in a call meeting either Thursday or Friday upon adjournment. So at this time, we'll proceed with the bills that we have in front of us. So the chair lays out House Bill 870 and recognizes Representative Thompson to explain the bill.
Good morning, Mr. Chairman and members. When you hear this bill, you're gonna wanna vote it out before I even finish my testimony. I can assure you, it's just that good. Here's what it's gonna do to help Texans, and it's gonna save the economy, and we're gonna get people back to work. This bill wants to reduce persons who are on deferred adjudication probation. It's going to allow them to file a petition, and if you're on a state jail felony or misdemeanor, your waiting period is normally 2 years. We want to reduce it to 1 if your conduct is okay. And if you are on a felony deferred adjudication, the waiting period now is 5 years, and we want to reduce it down to 3. That's all it does. And if you want to take the vote, I'd be happy to stand back there, and the regular calendar would be fine, Mr. Chairman.
Now, Chair Thompson, I tell you, one other thing you could do is you could wish Representative Bales a happy birthday today.
Happy birthday to ya. Happy birthday to ya. Happy birthday. Is that okay?
That's right. That's right.
That's the double vote now.
Members, are there any questions for Chair Thompson? If not, we'll recognize her right to close. So we do have, I guess, one person registered. The chair calls Shay Place. Good morning, and we appreciate you being here. And of course, if you'll tell us who you are and who you represent and your position on the bill.
Yes. Good morning. My name is Shay Place. I'm testifying on behalf of the Texas Criminal Defense Lawyers Association, and we are in support of this bill. Not that I could say anything more than Chair Thompson has already said. This exact bill did pass the House in 2019, but did not make it through the Senate before the session ended. It's a very simple bill, as you just heard, that just reduces the time limits for when a person can apply for that order of non-disclosure following successful completion of a period of deferred adjudication community supervision. I'd like to make clear that a person can only apply for this non-disclosure upon successful completion of the community supervision, meaning that they've done everything that was asked of them in that initial time period, and then they've also received a discharge and dismissal of the charge. And so the essence of the bill is just to encourage those individuals who are on deferred adjudication to do everything that they can to succeed in hopes to then receive a non-disclosure. The bill allows a person who has done everything they were asked to do to either get back to work, possibly get a better job, seek further education, as well as to improve their family life or economic security just a little bit sooner. Basically, just get their lives back on track just a little sooner. And we do hope to see this bill once again sit to the Senate. Thank you.
Thank you very much. Members, do you have any questions? We appreciate your time.
Thank you.
We don't show that anyone else is registered to testify on this bill. So is there anyone else who wishes to testify on, for, or against House Bill 870? Seeing none, the chair recognizes Chair Thompson to close.
Mr. Chairman, members, I close. If you want me to wait around, it'll be fine. This is a good bill, and I think that it's going to shrink government, but more importantly, we're going to be helping to restore lives, and we're going to help the economy by doing this. So,
Thank you, Chair
I wish I
Johnson.
could vote myself, but I'm not on the.
Members, any questions?
Thank you so much.
If there's no objection, we'll leave House Bill 870 pending. There it is. The chair lays out House Bill 385 and recognizes Representative Pacheco to explain the bill. And Representative, I see that you have a committee substitute, is that correct?
That is correct.
So at this time, the chair lays out the committee substitute to House Bill 385 and recognizes Representative Pacheco to explain the measure.
Okay. Thank you, Chairman Murr, Vice Chair Allen, and distinguished colleagues of the committee. House Bill 385 is a very good bill. It passed in the last legislative session. It just ran out of time in the Senate, just like 1 week short. And so we're pushing this bill. It's a very good bill. This is one of these bills that we talk about criminal justice reform, keeping people out of jail for crimes that are just nonviolent crimes. This has to do with somebody being on probation and having to go through the probation process. Now, when you're on probation, you have to go visit your probation officer, and it always costs money. Well, it's very difficult when the people on probation are having a hard time finding work because nobody wants to let them go in the middle of the week to go see their probation officer. I've seen it when I worked at the Bexar County Courthouse. I've seen the situations, and so this bill will allow judges to give someone community service to be able to go out into their community and work off their fees that they have to pay. It costs more money for us to send somebody back to jail because they can't pay fees. It doesn't make sense if you do the math. It just doesn't. And so this would strengthen how we treat people and stop putting in people back to jail that are not able to pay the fee. It's like a debtor's jail, right? That's been outlawed. We're not supposed to do that anymore, send somebody to jail because they owe money. It's supposed to be, we've done away with that, but technically, it doesn't have that name, but it's still happening. We have a debtor's jail when people can't afford fees. So this law would strengthen and clarify the system for the existing early discharge review process, strengthen incentives for people on probation to complete supervision in a timely fashion, judiciously use conditions to achieve the objectives of supervision, and align the ability to pay standard for probation costs, which standards passed over the last two sessions for all other criminal court fines and fees. We'll hear from stakeholders about the probation we have a couple of witnesses, but this is something that is very important to the community, is very important to myself, and I reserve the right to close.
Thank you, Representative. Members, do you have any questions? We'll recognize your right to close, and we do have a few people that have registered to testify. The chair calls Tara Tucker. Good morning, Ms. Tucker. If you'll tell us your name, who you represent, and your position on the bill.
Good morning. My name is Tara Tucker, and I am the Texas State Director for Alliance for Safety and Justice. We're testifying in support of House Bill 385. Thank you, Representative Pacheco and Chairman Murr, for your leadership. We think this measure is a very important, positive step in the right direction. I will recap some background information that supports why we need this bill. First, we are the first organization in the country to actually research crime victims' views on safety and justice, and we have 5,000 members in Texas. In 2019, we completed a survey of Texas crime victims. The findings of the survey attached to my testimony. Throughout our research, we learned victims want two things: for what happened to them not to happen again, and for it not to happen to anyone else. The most important purpose of the system is to protect victims and improve safety. In 2020, we released a report analyzing data on probation terms that is also attached to my testimony. What we see is in Texas that people are staying on probation too long, often because it's too expensive for them and not for a public safety purpose, and that conditions can be duplicative and counterproductive to rehabilitation goals. Far too many people are actually choosing to go to state jails, which is a more expensive option for Texas, rather than getting treatment in the community. The way Texas community-based treatment is set up is counterproductive. It's a huge price tag for a group of people that don't have any money to begin with. The conditions are prohibitive and often unclear, that often they interfere with what actually breaks the cycle of crime, which is stable housing and employment. We have actually created a disincentive for people to take probation by creating a state jail system where we can opt out of treatment and accountability and just sit it out for months and then have no supervision to see if they've actually turned their lives around. We can and should do better. Now, for some, not all, trauma and domestic abuse are drivers of addiction, theft, and other self-destructive behaviors. We're going to have to take that on. Crime victims in Texas are saying they want to see a system we have in place actually break the cycle of crime and create productive members of society. If we know people are accepting jail and prison time to avoid paying fees they can't afford, avoid reporting for multiple years and because they feel set up, and it isn't increasing public safety or creating accountability, and it's costing taxpayers a lot of money, then we have to make a change. House Bill 385 addresses these very issues by incentivizing probationers to participate diligently in their own rehabilitation and strengthen the avenues for earlier termination with judicial approval, ensuring appropriate financial penalties are paid by strengthening the ability to pay evaluation of probationers, and better aligning the conditions of probation with the individual's risk, needs, and making sure that people on probation are more clear on what the rules are, and that they must follow the probation officer and what the probation officer must enforce. Thank you for your time. I'm really, really excited about this bill, and I'll answer any questions.
Thank you, Ms. Tucker. Members, do you have any questions? We appreciate your testimony and your information that you provided us. The chair calls Molly Westfall. And I guess I should clarify, Judge Westfall. And if you would you tell us your name, who you represent, and your position on the bill?
My name is Molly Westfall. I'm a district judge. I represent myself, and I'm for this bill. We have had a lot of discussion back and forth with Representative Pacheco and people around the bill about what needs to go in the bill. And in its current form, I think, to my way of thinking, I run a felony criminal court. I've been in the criminal justice system for 25 years now, 10 years as a prosecutor, 15 years as a judge. So I have had a lot of chances to see how the criminal justice system actually works. And this bill really codifies what we do, at least in Tarrant County. And I think it adds some protections that are good and needed. There is one change that I've talked to the bill author about making as far as judicial findings that I think that is going to be changed as I understand it. With that change, I'm totally for the bill.
Thank you, Judge. And just to clarify, so in your job, do you preside over criminal matters?
Exclusively.
Okay, and what type of criminal matters?
Felonies.
Okay, and then how frequently do you see matters involving some of the areas that we are talking about here today, especially on probation?
Every single day. A large part of every felony criminal court or any judge who handles criminal matters is supervising people on probation. I have about 1,000 people under my supervision on probation from the 371st District Court currently and basically year to year. So I handle probation matters every day. It's a huge part of what we do. Everybody tends to think of district judges as being sitting in a trial and presiding, but a lot of what we do has to do with dealing with probation and other matters.
And Judge, just as a measuring tool or an ability to...
I can take this off.
You are welcome to take that off while you're speaking.
That's what I'll do then.
As an instrument to try to measure success with changes that occur, you probably have in the process of monitoring folks that are on community supervision. you have motions to revoke or motions to amend or extend. Do you believe that there would be some numerical data if these changes proposed in this legislation occurred where you might see reductions in the motions to revoke probation or the motions to proceed that get filed because of successful completion of the terms of probation?
I hope that we would. I mean, we always strive for successful completion. When we have people on probation, my sole goal is to get them across the finish line and have them successfully complete. And I think more data always tells us what we're doing and where we can improve. And I love data personally, and anything that generates more data is all good for the criminal justice system.
Thank you, Judge. Members, Mr. Sherman has a question for you.
Thank you, Chairman Murr. Judge, thank you for coming to Austin to speak with us, and I appreciate your experience that you're able to address this legislative body from and give us your insight. As you look at his Representative Pacheco's bill, and you've certainly considered it enough to say that you're for it, have you found that there are any issues with this in regards to, he mentioned debtor's jail. Have you found some courts that do send individuals back to prison because they can't meet that obligation?
I can tell you from my 25 years in the criminal justice system, that doesn't happen in Tarrant County. And when I was a prosecutor, usually we would put every single violation of somebody's conditions on a petition to revoke. But now we don't even, in my court, we don't even include allegations of failure to pay because there's an affirmative defense for failure to pay, and all somebody has to do is have someone get up during the revocation hearing and say, I can't pay. And then it's on the state to prove that they can pay. But I do hear stories about, every single time that we're involved in the legislative session that this is happening in other counties. I can't speak to what's happening in other counties. I can tell you in Tarrant County, I have never seen anyone go to prison for failure to pay, but that should never happen in any county.
Okay. Well, we have 254 counties.
I understand.
Yeah.
I'm not responsible for those 253 counties, just Tarrant County, but it doesn't happen there, and it shouldn't happen.
So thank you for your service.
Members, is there any other questions? We appreciate you being here today.
Thank you.
Members, we don't have anyone else that's registered to testify, but we do have multiple resource witnesses. If anyone has questions of probation or of the state in any matter. And I do think that I have one question, so the chair will call Leighton Isles. Mr. Isles, if you'll tell us who you are and who you represent and your position on the bill for us.
Yes, good afternoon, Chairman and members. Leighton Isles, Director of Tarrant County Community Supervision and Corrections Department. I've registered neutral as a resource witness.
Thank you very much. So you're familiar with the legislation that we're talking about at this time, and you've reviewed it. Would you give us an overview of what impacts would that make to persons serving on community supervision, which will shorten to probation?
Well, one impact that strikes me is that it would codify a formal process for individuals to file when they are having trouble paying. And it would codify and put in writing a formal form. I do believe this happens informally every day. The bill highlights one of our struggles with the whole system is that we're relying on probation supervision fees. So that's really the heart of the matter. But we work with individuals all the time on waiving fees, reducing fees, bringing those matters to the court on behalf of the defendant or the department. When we see that someone can't pay, this would put a formal process to file with the court in place.
So right now, informally, if someone has an inability to pay, I know my experience has been when they can't pay, they don't report. But if they do report, what is the process that you currently follow? And I'm assuming maybe that's a best practice. Is what I'm wondering.
Yes, sir. So we require budget forms on every individual.
Okay.
And we go through their budget, and we look at that, and when the individual's struggling to pay or indicates that they cannot pay, we take a hard look at that and work with them, provide proof, bills, so on and so forth. And ultimately, we will petition the court to waive or reduce their fees when we see a hardship and they're unable to pay.
We appreciate your information. Members, do you have any questions? Mr. Sherman.
Just going back to the statement you made about the pay, that these individuals pay, so much of your budget too is reliant on those that are on probation being able to meet that obligation. Is that correct?
That's correct.
So the incentive that your officers have is what to get them to pay. I mean, I'm trying to think of this as a business model. And if I had a used car lot, and Chairman White and I were in business together, we've got this used car lot, and we've got car dealers out there selling. We pay them a commission every time they sell a car. If they don't sell many cars, we really probably won't keep them long. You have probation officers who, if they don't collect, what happens to the overall budget system?
So I guess I would say our incentive is to help make that individual across the desk that's under supervision successful. And that's the first and primary goal. It serves, doesn't serve the department, the public, to try to collect funds out of someone that cannot afford to pay. So this is what we do every day, is evaluate each and every individual circumstance. So if we can reasonably look at the situation and gather information and communicate with the court that this person, in fact, is on disability or cannot pay at this time, and that may change in 6 months. Okay, they may get a better job. They may be back on their feet. So I think it's important that you look at the inability to pay is not for the next 10 years. It may be for a 6-month period of time they need help, or 12 months. So that would be that's our incentive. But the reality is, and as I made the statement early on, our entire system is set up where between 40-60% of our budgets are relying on supervision fees. And that's just another conversation that I think we would love to have in earnest at a time with a session to try to address that. But this addresses and codifies the individual.
And so you make a valid point, and Mr. Sherman, you brought that up as well. There's a state policy discussion to have on how we go about funding community supervision. And so I'm looking here at the folks that write the budget, and I implore that discussion that needs to happen over the course of several sessions, I think, because that is a challenging obstacle when you are addressing folks' ability to pay. It's been my experience that someone will have a fine and court costs, but the costs of probation fees over the life of their duration on probation can equal or be greater than what the fine and the court costs were. And so that's the struggle that they have to deal with.
And
Yeah.
thank you, Chairman. And duly noted, I will take that back to appropriations. But I think that, in the business model, we would just ding their credit score. And so they would fill it in their credit score, and they would have to pay higher interest to buy things because their credit score has been lowered, and they may not qualify to buy things. But it would seem in the other counties, perhaps, or some counties, their only default is to re-incarcerate the person or incarcerate them if they're on probation. So that just concerns me. It's sort of problematic. Thank you.
Thank you, Mr. Isles. Members, any other questions? We appreciate you being here today. Thank you. We don't show that anyone else is registered to testify, so at this time, is there anyone else who wishes to testify on, for, or against House Bill 385? Seeing none, the chair recognizes Representative Pacheco to close.
Mr. Chair, thank you. Team, thank you. Just want to close real quickly with, it costs nearly 14 times as much each day to incarcerate someone in state jail than to supervise them on probation. And so that's why this is a very good bill, and I'm very proud to carry this bill. And with that, there's no questions. I close.
Members, are there any questions? We appreciate you, and if there are no objections, the committee substitute is withdrawn, and if there's no objection, House Bill 385 will be left pending.
Thank you very much.
Chairman White, are you comfortable and ready to go?
Yes, which one want me to start?
Whichever one is on top. Do you have a preference?
HB 2445, it's on top.
There we go. The chair lays out House Bill 2445 and recognizes Representative White to explain the bill.
Thank you very much, Mr. Chairman. House Bill 2445. We can all agree that our veterans, those who have served our country selflessly, deserve the benefits they were promised upon an honorable exit. Medical, education, and housing are all staples to ensure that they are well supported after their service. Of course, there are hundreds of veterans who are also serving periods of incarceration, parole, and probation, many of which separated from their military service with benefits. These veterans still are entitled to the benefits they earned during their service. In efforts to support them and reduce recidivism, TDCJ should continue to have an inventory of all benefits eligible to incarcerated veterans at all points of entry to and exit from incarceration and supervision. TDCJ should also continue to have strategies to leverage these benefits to enhance reentry and rehabilitation, educational opportunities, financial support for the family of incarcerated veterans, medical and psychiatric access, and cost efficiencies for TDCJ and the taxpayers of Texas. House Bill 2445 asks that TDCJ shall develop a comprehensive plan to ensure the successful reentry and reintegration of all identified veterans into their community. To do this, TDCJ will confirm the veteran status of each justice-involved person that is committed to a term of incarceration. If the incarcerated justice-involved person is a veteran, despite the manner of service separation, TDCJ will determine and inventory all eligible veterans' benefits. TDCJ will develop an incorporation of veteran benefit plan for every incarcerated veteran that enhances his or her eventual reentry, rehabilitation, medical, psychiatric access, and educational opportunities, housing, etc. Just as all of those who are justice involved, our veterans need access to all benefits and programs afforded to them to ensure a successful reentry and to reduce their rates of recidivism. That's my layout.
Thank you, Chairman White. Members, do you have any questions? And we'll recognize your right to close. And I do believe we do have one person that's registered to testify. The chair calls Charlie Maloff. Good morning, sir. Good to see you. If you'll tell us who you are, who you're with, and your position on the bill.
Good morning, Mr. Chairman, members of the committee. My name is Charlie Maloff. I am representing myself, and I'm here because I am for 2445. I'm honorably retired, decorated public servant, and military veteran, and I'm also formerly incarcerated. This bill supports the necessity of identifying veteran status of inmates incarcerated at the TDCJ. Last session, it was brought out that there were over 14,000 veterans incarcerated. I have no idea what the numbers are today, but for one class of inmates, that's a high number. While incarcerated, I was a life skills instructor at Diebold, and for over 2 years, I worked with the teacher's aide and assisted the vocation carpentry instructor at the PAC-1 unit. In those classes, I encountered a number of veterans who had been cut off from their benefits or had not the opportunity to register with the VA before being sent to TDCJ. At Diebold, we were blessed. The principal happened to belong to the same Rotary Club as the area veterans coordinator for the disabled American veterans. They coordinated and hosted a veterans group meeting of 24 of us just to help those that had problems get the road to resolution. Many of the veterans have substance abuse problems. Others have medical issues that were previously treated by the VA, but when they entered into the TDCJ, the treatment stopped. While a number had family members to help or grievance or file paperwork. Others had no family to assist them, but they still, too, had the serious medical or mental problems that needed ongoing treatment. We know a significant number of homeless are veterans. Some of these are incarcerated, were homeless when they committed their crimes. It can be expected, once released, they will end up back on the streets because there's no one to assist them or push them to keep them up with the provided assistance. I have a personal story I'd like to interject real quick. When I was at Diebold, there was a young soldier there who had lost his leg for stepping on a mine. That led to substance abuse. That led to crime. When he got into TDCJ, he was having problems with medical, constantly grieving because he couldn't get the treatment, and he was getting no substance abuse treatment. So all it was doing was just putting this guy deeper into an abyss. And I believe this bill really will assist all of the veterans in getting utilization to be able to use all of their state and federal benefits both during and after incarceration. Each veteran's plan needs to start as soon as they are identified and aggressively monitored throughout the incarceration. The condition of parole can also be the ongoing maintenance and sustainment of what this bill provides to assist in successful long-term transition back to society. So I respectfully appreciate your vote to move this thing forward. Thank you.
Mr. Maliff, we appreciate your testimony. Members, do you have any questions? Thank you for being here today. So those are all the folks that have registered to testify. Is there anyone else who wishes to testify on, for, or against House Bill 2445? Seeing none, the chair recognizes Representative White to close.
I close.
Thank you, Representative White. If there's no objection, House Bill 2445 will be left pending. And to interrupt your flow, I see that Chairman Leach has joined us, so
Yes.
we're going to... Chair lays out House Bill 3598 and recognizes Representative Leach to explain the bill. Good morning, sir.
Hey, good morning, Mr. Chairman, Vice Chair Allen, and members. Appreciate you allowing me the opportunity this morning to lay out House Bill 3598. Members, this bill it's unfortunately one of those bills that comes our way inspired out of a tragic situation that occurred back in 2015. Members, in 2015, Lauren and CJ Davis were out celebrating CJ's 26th birthday in Dallas. Date night out, just the two of them with tickets to the Mavericks game. While crossing the street on the way to the game that evening, a drunk driver struck and killed them both. Members, it took 3.5 years before any sentence would be delivered. And in the end, the man who struck and killed them both, a man who had 2 previous DWIs on his record, this man who's responsible for the deaths of 2 bright, promising young people, this man would serve only 4 months behind bars and a following probation sentence. Members, the families of Lauren and CJ, who are with us today, not only have had to live with the gut-wrenching, unending heartache of losing a child, but also with the distress of a justice system that they believe has failed them. And I agree. House Bill 3598 seeks to prevent injustices like this by mandating that intoxication manslaughter carry a minimum 5-year imprisonment term. Judicial discretion is still maintained in this bill. This bill allows judges to reduce that sentence if the judge finds it in the best interest of the community, and if the judge finds that the public would not be harmed by a reduction in that sentence. But importantly, the bill also requires that the judge enter that finding into the record. Members, intoxication manslaughter under current law is a second-degree felony and should carry a sentence of 2 to 20 years imprisonment. But in some tragic cases, like this one, like the case of Lauren and CJ, the perpetrator received what I think all of us would agree, hopefully would agree, is minimal jail time, 4 months. When a life is lost due to another's reckless, dangerous, and illegal behavior, we must ensure that the punishment fits the crime, that justice is served, and that future crimes are deterred to the extent possible. Members, I'm happy to answer any questions. Have witnesses here, a few witnesses here today to speak to their story and their experience, including the families of Lauren and CJ. Mr. Chairman, I reserve the right to close.
Thank you, sir. Members, are there any questions? And we'll recognize your right to close. We do have several witnesses. And if I haven't already, I just wanted to recognize that Representative Rodriguez has joined us this morning. Good morning. The chair calls Troy Bethall. And I'm guessing there are two ways to pronounce your last name, so if I've messed it up, please correct us.
That's fine. It's Benthal.
Benthal.
Yep.
So if you'll tell us your name, who you represent, and your position on the bill, please.
Okay. My name is Troy Benthal, and I'm representing myself as well as the family of Lauren and C.J. Davis. I am Lauren's father. And first of all, I'd like to say thank you all very much for representing the committee here today and taking the time out to listen to our story. I live in District 6 in Arlington, Texas, and I am here today in support of the legislation to help support stricter laws of driving while intoxicated or driving under the influence. And what I'm speaking about today is Bill number 3598. This has become an issue that is more than just numbers representing statistics that you may read or see on TV, radio, on the web, or other media. I've been directly affected by the results of an individual driving under the influence, and I have suffered the loss of my 26-year-old daughter and her husband. With respect of law enforcement of the Dallas Police Department, the Texas Rangers, the Dallas County Courts, several attorneys, judges, there's an individual who pleaded guilty and after 4 years of waiting time, served 120 days in jail that were non-consecutive over a period of 5 years of his probation. In the meantime, my 5 years of Thanksgivings and Christmases and birthdays and New Year's, and to be honest, just regular days of the week have been a very gut-wrenching loss of my daughter Lauren and her husband CJ. We were told that this was going to be an open and shut case, that there would be no possibility with this individual being let loose or even entertaining a plea bargain. And if there was even the slightest ability for a person to have a plea bargain, that he would be accompanied with double-digit years of jail time. We could only move forward and deal with our grief. And in the days of our grieving and sympathy and ever-present loss, 3.5 years later, we were told the unbelievable conclusion that this guy is going to plead guilty because there are no reliable witnesses. The arresting officer was arrested in a domestic issue himself and needed counseling. The jail person who drew the blood of the intoxicated driver had an outburst at work and therefore was an unreliable witness. I's were not dotted and T's were not crossed, all resulting in a lack of incompetency for this man to stand trial. However, the basic issue, the basic cause, the very basic facts of this nature never changed. A crime was committed with a man behind the wheel who was driving while under the influence of alcohol and illegal drugs, causing a crash and wrecking another car before striking and killing a beautiful young couple celebrating a birthday. Please understand, no parent wants to have to bury their children because of a senseless crime. And don't forget, this is a crime. In the great state of Texas, these laws have some loopholes and there's some gaps that need to be filled. Please support Bill 3598 to stiffen the laws of crimes of this nature. And if you have any questions or any thing that you want to discuss, I would very much like to meet with you in the future. And today, I really appreciate your time and your invaluable service to the people of the great state of Texas.
Thank you, Mr. Benthal.
Thank you.
Members, do you have any questions? We appreciate that you took the time to be here and to share that very personal story with us, and that has a lot of meaning. So, thank you. The chair calls Tammy Benthal. Good morning. If you'll tell us your name, who you represent, and your position on the bill. And also, I'm going to ask the Assistant Committee Clerk to adjust the microphone down so that anybody that is watching can hear you.
My name is Tammy Benthal, and I'm speaking in support of House Bill 3598. My testimony sounds a lot like my husband's, even though I hadn't read his and he hadn't read mine. But I come to you as a grieving mother of Lauren Benthal Davis and mother-in-law of Cedric Davis Jr., known as CJ. Let me share my story. Our world was forever changed when we got the news that my daughter Lauren and son-in-law Cedric, CJ, were ran over by a drunk driver on November 13th, 2015 at 7:15 p.m. They were walking to a Dallas Mavs game to celebrate CJ's birthday and had just been 4 days earlier. Both were only 26 years old and had been happily married only a year and a half. The drunk driver who ran the intersection lot hit another vehicle before plowing into Lauren and CJ. He was so intoxicated that he did not know he hit them, even though my daughter's body smashed his windshield in. She then was catapulted into a 10-foot retaining wall where she fell to the sidewalk. CJ was thrown into a tree by the vehicle, killing him instantly. Lauren was pronounced dead at Parkland Hospital the next morning after a MRI ruled out she was brain dead. She never regained consciousness from the crash scene. To say our senseless loss of our children devastated our families is an understatement. The years that followed were a continued nightmare. For 3.5 years, we were assured this was an open and shut case. However, during this time, the trial was scheduled and then canceled 6 times for various reasons. In mid-2019, with still no trial in sight, the prosecutor called yet another meeting to tell us that he had made a decision to offer the drunk driver a plea bargain. Our family was against this, but he had already offered it to Chris Mons, who was the drunk driver, his lawyer. I find this hard to believe that the only punishment the drunk driver received was 120 days in county jail and 5 years probation. Not prison, but probation for killing our loved ones. This is the reason we want House Bill 3598 to pass. It would change the minimum prison time from 2 years to 5 years, and Texas needs stronger laws in place for this preventable crime. We don't want other families to go through what we did. I plead with you to pass this bill 3598 onto the House floor. Respectfully, Tammy Benthal.
Thank you, Ms. Benthal. We appreciate you sharing that. Members, do you have any questions? You do bring a serious issue towards us. Real quick, just want to make sure we have a clean record. It's important for the bill. Whenever I ask you who you represent yourself.
Yes.
Is that correct?
Okay. Yes.
Members, any questions? Thank you for being here.
Thank you.
The chair calls Susan Davis. Good morning, Ms. Davis.
Good morning.
If you'll tell us your name, who you represent, and your position on the bill.
Is it okay if I take this?
Yes, ma'am.
Thank you. Good morning, committee members, and thank you for allowing us to be here today to share our story with you. on why we steadfastly believe House Bill 3598 should be passed. My name is Susan Davis. I represent myself, and I'm the mother of Cedric Terrell Davis Jr., otherwise known as CJ. I brought a picture of CJ and Lauren, if it's okay. Can I put it right here?
Yes, ma'am.
I don't know if y'all can see it very well.
Got it.
And I apologize in advance if my story sounds much the same as Tammy and Troy's.
That's okay. We want you to tell your story today, and it's very important. And as you begin, just confirming that you are in favor of the bill.
I am in favor of
Please
this
proceed.
bill.
Yes, ma'am.
Thank you. On Friday, November 13th, 2015, I received that phone call that no parent wants to get. It's the hospital stating that your child has been involved in an accident, and it's critical that you get to the hospital as soon as possible. CJ and my daughter-in-law, Lauren, were hit and killed by a drunk driver as they were walking down the sidewalk headed to a Dallas Mavericks game. His 26th birthday was just 4 days prior to this, and this game was my daughter-in-law's surprise birthday present to him. He loved the Mavericks. Upon arriving at the hospital, we learned that CJ was killed instantly at the scene, and that Lauren was taken to a different hospital and was in surgery. From our very first meeting with detectives while at the hospital, and then later with the Dallas County prosecutor, we were told this was an open and closed case, and this guy was definitely going to do time in prison. The prosecutor even went so far as to tell us he would never offer a plea deal in this case because the evidence was so clear. The evidence was the driver was speeding through a construction zone in downtown. He ran 2 red lights and was clearly drunk. Although, as stated by witnesses, he seemed oblivious to the fact that he had just hit 2 people. And when his lab work came back, not only was he nearly twice over the legal limit for alcohol, but he also had drugs in his system. To make matters worse, through our own investigation, before even meeting with the prosecutor, we learned that this driver had previous convictions in another state. During the process of having numerous trial dates set and canceled over the course of almost 4 years after losing our children, our grieving families were told that the prosecutor's office had decided to offer a plea deal in exchange for the guilty plea. Why, you ask? Basically, because there were too many technicalities against us, most of which had absolutely nothing to do with the facts in this case, but more to do with the Dallas Police Department's failure to effectively and correctly do their jobs. In short, the drunk driver received a sentence of 120 days in county jail, not consecutively, over a course of 5 years probation. Nothing more than a slap on the wrist for the accused for killing 2 people and a slap in the face to our grieving families. Imagine yourself in our shoes for a moment, if you will, having this scenario play out before you. Then ask yourself, how does this happen? How does this happen in the state of Texas? How is this person not held accountable for his actions? It was not an accident. He willingly and knowingly got in that vehicle after drinking and whatever else he was doing. It was not an accident. To say the very least, both of our families were failed miserably by the Dallas County Police Department, the Dallas County Prosecutor's Office, and the Dallas County court system. There was no justice in this case for our children, and we hope we won't be failed by the state of Texas as well. As a grieving mother, my world has been rocked to the core and will never be the same. I will never be the same. My surviving children will never be the same. I wouldn't wish this nightmare on anyone, and I pray that none of you should ever have to live through a nightmare such as this, because I assure you it is never ending. We live it every single day. I implore you to please pass House Bill 3598. We must demand tougher laws for drunk drivers, especially when fatalities are involved. Thank you so much for your time.
Thank you, Ms. Davis. Members, do you have any questions? I have one question for you, Ms. Davis, just a technical question.
Yes, sir.
So you testified that you met the prosecutor right when it occurred, but that 4 years elapsed before you saw the case resolved.
Yes, sir.
Was it the same prosecutor
Yes.
for the whole duration?
Yes, sir, it was.
All right, that's my one question. Wanted to know.
Absolutely.
Members, do you have any other questions? Thank you for taking the time.
Thank you.
Yes, ma'am. We don't show anyone else who's registered to testify today. Is there anyone else who wishes to testify on, for, or against House Bill 3598? If you'll visit with the Assistant Committee Clerk.
He's registered, so he can go ahead and speak. We just need to change it in the records.
Okay. If you want to go ahead and go to the microphone. Yes, sir. So you were registered.
Yes, but I want to change I was against. I'd like to do it to neutral and testify.
Okay, so if you'll go ahead and tell us your name, who you represent, and your position on the bill.
Yeah, hi, my name is Jorge Renault. I'm the Southwest Region Director for Policy and Advocacy for Latino Justice, and I want to testify on the bill.
And you had previously registered that you were not going to testify, so let
Yes.
the record reflect that you were testifying, and then you previously had registered against the bill, but we want to change that so that it shows that you were neutral
Yes.
or on the bill.
If possible, yes.
And that is done?
Yes.
And then is there any other testimony that you'd like to provide?
Yes, I would. I changed my testimony because of the undeniable pain that I just saw. And, but I do want to make a commentary. I am against incarceration, but I also understand that we have very little to offer the survivors of violence other than incarceration in this state, in this country. It would cost a minimum, I think, of something like maybe anywhere $45,000 to $60,000 to incarcerate someone in TDC jail over 5 years. I would suggest that this piece of legislation also offer that same amount of money paid for by the state to the survivors of this violence for whatever therapeutic alternatives they have so they can go through some healing. Because I don't know if that's always offered. All we want to do is put someone in jail as if that's going to help the individual who is actually coming up here and suffering this sort of pain and anguish. Why can't we fund something for these individuals so they can go through some meaningful healing alternatives? I think they deserve that. I'm not going to address the part of incarceration right now because I'm going to honor their experience. But I would suggest to the representative that that piece of legislation is missing and that we leave it up to them and that we say we're going to put this person away for a certain amount of time and it's up to you to heal. That if we're willing to foot the bill, to put someone in jail for that long, that we should be willing to foot the bill to give these people some meaningful alternatives to therapy and to assistance from other families or from someone to help them through that healing process because they deserve that from us. That's all I have to say.
Thank you, Mr. Renaud. Members, do you have any questions? We appreciate you taking the time to testify. Is there anyone else who wishes to testify on, for, or against House Bill 3598? Seeing none, the chair recognizes Representative Leach to close.
Thank you, Mr. Chairman and members. In my brief closing, first of all, I want to thank the families, and it's been a joy and a blessing to get to know you, and I appreciate, and I know the committee appreciates your testimony. And to the gentleman who just testified, I'll just say this: that I know these families well enough to know that they do not want money; they want justice. And in this case, in some cases, I will agree with the witness that there's more to justice than just putting someone away and locking them away in imprisonment. But in this case, the families were not even given an opportunity to have a say in the plea deal. This man who killed 2 Texans, their children, 2 26-year-olds, this man spent less time in prison than we will spend in this building this legislative session. Our legislative sessions are pretty short, 140 days. I know some days may feel like it's longer than that, but this man spent less time in prison for killing 2 people than we'll spend in this building this legislative session. That is not just, and that is not right. So I would ask, Mr. Chairman and members, that you give this bill favorable consideration. The only amendment that I can think of that we would want to offer on the floor is, if the families are willing, an amendment that would title this Lauren and CJ's Law. And I hope that although in their case they may not have received the ultimate justice that they wanted, I hope that we as a legislature can right this wrong and make this right and provide justice for, unfortunately, countless Texans who will be in their position in the future. So, Mr. Chairman, thank you. I know you've got a busy agenda. I'm happy to take questions.
I have a question.
Mr. Burrows.
Thank you for bringing the bill. Obviously, compelling testimony, and certainly understand why you brought it. I do, and you may not know the answer to this. It sounds like the investigating officer messed this up at some point in level. Do you know anything about that, and any disciplinary action happened to them?
Yeah, thank you, Chairman Burrows, for the question. There were mess ups, Chairman, all over the board on this. From the investigator, the police, from some of the testing, the judge, the prosecutor. I mean, this was a complete failure of our system. But which is one of the reasons that, yes, we want to escalate the punishment and provide a minimum of 5 years, but we've also allowed judges the discretion to put it in the record. So when a judge says, well, we're not going to give 5 years, maybe we'll give 2 or 3, that's actually a part of the record going forward. Right now, there's no part of this record, Chairman, that tells them, the families, or the public why this man was only given 120 days and a slap on the wrist.
Fair.
So,
thank you.
Mr. Sherman?
Thank you.
Thank you, Chairman Murphy. I would concur with Chairman Burrows. I appreciate you bringing this legislation to us and to the Benthall family and the Davis family. Thank you for your courage to come to address this legislative body in memory of your son and daughter. Unfortunately, you're not alone.
Mm-hmm.
You know, I think of Ethan Couch, who killed drunk driving, killed 4 or 5 people. And the only sentence that young man received was 2 years probation. He didn't serve any time at the time of the conviction. And your legislation, Lord's will help us to bring more justice to families. I'm grateful for the Davis and Benthall family because this won't do anything for their case, but it may help some other family that they won't have to experience this same sort of insult to their loss. So thank you.
Thank you. Thank you.
Chairman White? Oh, okay. Any other questions?
Chairman, thank you.
Absolutely. Thank you, Representative Leach. If there's no objection, House Bill 3598 will be left pending. Chairman White, are you comfortable to go back and work on, is 1894 next on your list? Okay. The chair lays out House Bill 1894 and recognizes Representative White to explain the bill.
Thank you very much, Mr. Chairman. 1894 deals with former felons. They have served their terms of incarceration and or supervision and have found success economically and financially. Those do exist. A lot of them exist. They have jobs and their voting rights, but their prior convictions impair their ability to exercise other constitutional rights. In some instances, their felony did not include the use of a firearm, but that constitutional right is impaired by their felony status. Unfortunately, the felony conviction strips them, like I said, of their Second Amendment rights and therefore impacts their ability to engage in certain recreational purposes like hunting. In many instances, those who have been formally convicted and have been off paper for decades, proving their rehabilitation and reintegration into society. This alienation and marginalization of so many Texans is not indicative nor representative of our democratic society. In the past, the Board of Pardons and Parole has reviewed many criminal files of people who have been convicted of felonies and if warranted, have recommended clemency for these individuals to the governor. In order to minimize, I know there's a fiscal note on this, Mr. Chairman and members, and, you know, I'm still thinking about how to significantly reduce the fiscal note. The fiscal note is over $5 million over, a 2-year period, and 34 FTEs. A lot of folks. And I think based on the bill, I think I probably captured about, I think it was 52 or 56,000 felons. So that's probably a little bit too much. Okay, and it's driving the fiscal note, so we'll dive back into this and look into this. So that's pretty much the bill layout, Mr. Chair. If it's appropriate, I'll reserve the right to close.
Yes, sir. Members, are there any questions for Chairman White? And we'll recognize your right to close. Chairman White, we don't have anyone that's registered to testify. I'm confident if we do have some resource witnesses, if any members do have questions, we can call them up. And if not, then I'll ask, is there anyone else who wishes to testify on, for, or against House Bill 1894? Seeing none, the chair recognizes Representative White to close.
I close.
Thank you, Representative White. If there's no objection, House Bill 1894 will be left pending. So now the chair lays out House Bill 2442 and recognizes Representative White to explain the bill.
Yes, thank you very much, Mr. Chairman. As we know, there is an overwhelming issue of overcrowding in many of our justice facilities. As we've tried to encourage diversion, both to address overcrowding and reducing recidivism, often people on community supervision and other diversion programs are overwhelmed by fees and costs that they cannot afford to pay, which sets them up for failure sometimes and creates yet another path of incarceration. As a result, the state and local communities end up paying more money than they would if they sent them originally to the state prison system, despite the fact that the prison costs 7 times more than probation. This legislation would address both these problems by reimbursing counties up to 90% of the actual cost savings to the state by reducing their prison population through community supervision, diversion programs, improvements to indigent defense and other best practices, and incentivizing counties to develop a fund to offset the cost of community supervision. In this way, this legislation will save the state money and provide counties with the means to reinvest savings in strategies that decrease crime and reduce recidivism. And I have to add, these are things that counties are already doing. Okay, this would be to incentivize them to robust their programs in their local communities. The Justice Reinvestment Incentive Program will relieve the strain on both probation officers and individuals serving community supervision by refunding counties 45% of actual savings by reducing their TDCJ sentences over 2 years, so long as the reduction is at least 40%. In addition, this legislation will refund counties an additional 45% of actual savings if they use the money to offset supervision costs for people serving sentences of community supervision. Thank you very much, members.
Members, are there any questions? We will recognize your right to close. We do have several folks registered to testify. The chair calls Tara Tucker.
Good morning. Tara Tucker, State Director for Alliance for Safety and Justice, and I am testifying in support of House Bill 2442. This one will be shorter. Thank you, Representative White and Chairman Murr, again, for your leadership. Texas has a probation and pretrial system that is largely funded by people on probation and pretrial. The large percentage of this population is low income and cannot afford the costs. Because of the way our system is set up, people are not paying, then the department has to cut back. This causes caseloads to increase and results in diminishing returns on supervision and public safety. This happened this past year with where probation offices had to cut back as a result of COVID because people were losing their jobs and couldn't afford their fines and fees. House Bill 2442 allows local jurisdictions to create plans to reduce referrals to TDCJ, and in return they will receive a portion of the savings to apply toward fines and fees and programs for people who cannot pay. While it will require DAs, courts, and probation to work together. It's an excellent bill. It allows local jurisdictions to get creative in reducing commitments to TDCJ, and as a result, get a portion of the savings to go toward programs and fees. This way, people can still access probation, which yields better public safety results than prisons, and probation departments are not penalized for recognizing that everyone cannot pay. Right now, departments are incentivized to keep people longer on probation because they get money that they need to stay properly staffed and in adequate programming. Or now, there are people who avoid probation because it's too expensive. This bill is a good start in ensuring probation is funded correctly, regardless of whether people on probation can afford it. This bill begins to move our system to a system that can better focus on rehabilitation and not so much on collecting money. Thank you.
Thank you, Ms. Tucker. Members, are there any questions? We appreciate you being here. Thank you. The chair calls Harjeen Zabari. And you will have to correct my enunciation. So if you'll tell us your name, who you represent, and your position on the bill.
My name is Harjeen Zabari. So you were...
I got really close. Thank you.
There, yeah.
I'm going to give myself a silver star, not a gold star.
I work at the Texas Fair Defense Project, and I am for this bill.
Thank you.
Hello, so my name is Harjeen Zabari, as I've stated before. I specialize in probation-related issues at the TFDP, namely probation-related debt, and today I am speaking in support of this bill. Currently, probation in Texas is difficult for reasons one wouldn't expect. The payments associated with probation are often costly and burdensome for low-income folks. A probationer is on the hook for all the costs of probation, including a monthly probation fee, court fees, urinary analysis costs, and fees for the court-ordered classes that are a condition of their probation. Probation easily costs the person on probation over $1,000 a year, which is a huge strain on an already low-income family. Probationers are often forced to choose between providing for their family or paying off the cost of probation. Keep in mind, this is on top of the other obligations that already come with probation, like maintaining sobriety, going to supervision check-ins, doing community service, completing classes, and more. Probation officers who already have very difficult jobs are also having to play the role of collection agents. Supervision meetings often focus on the subject of outstanding payments rather than probationers' progress in life. Someone who is otherwise successful on probation by passing urinary analyses, completing community service hours, getting an education, will still find themselves in hot water with the probation department because of their outstanding fees. Even more upsetting, probation periods can be extended for failure to pay, even if all other conditions of probation were satisfied. People who are unable to pay their probation costs do not do so for lack of caring or lack of trying. They simply do not have the funds, and many express a feeling of helplessness in this situation. This is counterproductive to the purpose of probation, which is to help someone get their life back on track. This bill, which helps to offset these costs, will help redirect the focus of probation to its rightful place and set people up to succeed. By equipping counties' probation departments with more funds, Texans will get to remain in their communities with their families and work towards bettering their lives. I ask that you please support HB 2442. Thank you for your time.
Thank you for your testimony. Members, are there any questions? Thank you for being here. We appreciate that.
Thank you.
The chair calls Amelia Casas. If you'll please tell us your name, who you represent, and your position on the bill.
Thank you, Chair Vice Chair Allen, committee members. My name is Amelia Casas. I'm the policy analyst with the Texas Fair Defense Project, and we strongly support HB 2442, the Justice Reinvestment Incentive Program. Thank you so much, Chair White, for authoring this legislation, and Vice Chair Allen for signing on. We really appreciate it. HB 2442 addresses two large problems: Texas's high prison population and lack of funding for local strategies that decrease crime and reduce recidivism. This bill would fix misaligned financial incentives by reimbursing counties when they save the state money by sending fewer people to state prison. These savings will then be reinvested to help fund local community supervision and diversion programs that do decrease crime and reduce recidivism. So I want to spend a little time on just explaining the way it would work. A local authority, such as DA's office and judges, would create and implement a 2-year justice reinvestment plan, utilizing different strategies to reduce the number of people sent to prison in their discretion as they see fit. Examples could include pretrial diversion programs, increasing community supervision, or starting a public defender's office. If the jurisdiction reduces the amount of folks that they send to prison by 40% over the next 2 years, they would apply to receive 90% of the actual cost savings to the state. The reduction will be compared to the 2 years preceding January 1st, 2020, and this is completely intentional since many jurisdictions have already declined their prison commitments due to COVID, the pandemic, and so they may be further along in the process than realized. The costs that we calculated are purely using marginal costs without closing a prison or letting go of staff. The marginal cost savings per person is about $10,000 per each year. Lastly, upon receiving the reimbursement, the jurisdiction must put at least 1/2 of the award towards offsetting community supervision related costs or fees assessed against people on community supervision, allowing probation offices to spend less time worrying about collecting debt and more time setting people up on probation for success. So although commitment reduction plans are currently included in current statute, they are rarely used since they work more like a loan, and jurisdictions that don't meet their goals have to pay the state back. Oftentimes they had already spent the money. So the reinvestment program is flexible. It is set up to meet the individual needs of each jurisdiction, and it's not mandated, so any counties who want to opt in can and reap the benefits. We already have spoken to some jurisdictions that are excited about this legislation and support it and definitely see that they would use it if it were available. I ask that you please support HB 2442. Thank you very much.
Thank you, Ms. Casas. Members, any questions? We appreciate your testimony.
Thank you.
We don't show anyone else that's registered to testify. We do have resource witnesses if there is any questions for a resource witness. Is there anyone else who wishes to testify on, for, or against House Bill 2442? Seeing none, the chair recognizes Representative White to close.
Thank you, Mr. Chair and members. We think this is a very, very beautiful bill. We're not asking or telling DAs or judges to do anything. They don't like us to do that, and understand. I don't like to do it either. So these are people that they're already working with. They'll make the decisions if they want to work with them in their communities. And this is a great opportunity for the legislature to love and work with the local people. A lot of people say the legislature doesn't like the local people. I like my local people. Okay, I think they're great. I think they're very smart. And I think if they had these opportunities, working with the great people in TDCJ and with the probation folks, it'd just be a beautiful thing to have people working, sharing monies. I think it'd just be great. I close.
Members, any questions? Then we will, without objection, House Bill 2442 will be left pending. The chair lays out House Bill 757 and recognizes Representative Dutton to explain the bill. Good morning, Mr. Chairman.
Good morning, Mr. Chairman and members. Under current Texas law, there are two forms of probation. One is pre-conviction and the other is post-conviction. What I'm here today about is a pre-conviction probation, commonly referred to as deferred adjudication. And what this bill does is says that since it's not a conviction, it won't be used in housing or employment or in professional licenses. I think that's the truth in sentencing law, because when you get to a judge and you get deferred adjudication, one of the things the judge tells you is that when you successfully complete it, it won't be held against you. And so that's essentially all this bill does. I found this now for a couple of sessions, but I think this committee is smarter than the other committees. So with that, Mr. Chairman, I know it's a habit of people to say they reserve the right to close, but there is no such right under our rules, because the bill belongs to the committee at this point, not to the member. And so I can request the right to close, and so I do that.
Chairman White has questions.
Yeah, Chairman Dutton, good morning.
Good morning.
How long have you been bringing this bill? Seems like I've heard it every session I've...
Well, it started because and I think about 4 or 5 sessions ago, I had a case where a man was denied housing in my district, and he had a conviction actually, and so it started with that. But his conviction was 50 years old, and he was 80, and they wouldn't rent him an apartment. So I got to looking into this. And what I realized is that that was not just related to long-time convictions, but under deferred adjudication, there had been problems also because under federal law now, it's against the law to solely base a housing decision on whether a person has a conviction. But there's a question as to whether or not, if you don't have a conviction, could they use that? It is also, it's still a question as to whether or not some people who get deferred adjudication and to what extent can that be used later in employment, housing, or in professional licensing. And so I've been bringing it in a long time, but like I said earlier, I think this committee is smarter than the last one.
Any other questions?
I have no questions.
Thank you.
I was on the last committee.
I don't know where your vote count is now.
Well, I think he improved this committee with his experience from the last committee.
Mr. Chairman, we're gonna
Thank you, Mr.
we're gonna see there is no one that's registered to testify. And so I will ask, is there anyone who wishes to testify on, for, or against House Bill 757? Seeing none, we will recognize you to close.
Thank you, Mr. Chairman. I think the witnesses have gotten tired too. So they decided not to come back either. But I thank you all for this bill, and it's really just a truth in sentencing, because the law says that a deferred adjudication successfully completed is not a conviction, and unless there's been a conviction, I don't think it ought to be held against anybody for anything. And so with that, Mr. Chairman, I close.
Thank you, Chairman Dutton. If there's no objection, then House Bill 757 will be left pending. Do you want me to go ahead and do Sherman's too?
Yeah, go ahead.
Okay.
Go ahead.
You've got 7. We could try to cram it if you
Yeah,
want.
I'll ask them to cram it.
Well, we can pull you next. If you
Go.
Okay. The chair lays out House Bill 3547 and recognizes Dr. Allen to explain the bill.
Thank you, Ms. Chairman. Under current Texas law, incarcerated persons who successfully complete sentences of deferred adjudication or probation may be eligible to have their criminal records sealed via the non-disclosure process. Too many Texans citizens have difficulty finding employment and housing due to convictions and misdemeanor offenses. This bill offers them a second chance via the non-disclosure process. In a society where criminal histories play a major role in day-to-day decisions, it is essential that we allow, let me see, are you getting me? All right. Thank you, I'm sorry. In society where criminal records play a major role in day-to-day decisions, it is essential that we allow individuals who made mistakes an opportunity to correct them. House Bill 3547 expands eligibility for persons to petition the court for an order of non-disclosure after the certain period of time based on their offense. Once passed, this bill will allow persons in certain misdemeanor conviction records eligible to have their criminal records sealed via the non-disclosure process. Mr. Chairman, I do believe there are witnesses, and I'm encouraging my witness to be as brief as possible. It is almost 10 o'clock. We want to get it in. And I reserve the right to close.
All right, Dr. Allen, we appreciate that. Members, do you have any questions? Then we will recognize your right to close. And the chair calls Jennifer Toon. And just as an observation while you're arriving up here, so the committee is not allowed to meet when the House goes to the floor. It goes in session at 10. So regardless of where we are, we put the brakes on things before 10 o'clock. So
We'll have to come back.
That's right. That's just
Maybe
the concept
till
we have.
midnight.
So Ms. Toon, if you'll tell us your name, who you're with, and your position on the bill.
All right. Thank you, Chairman, and thank you, committee members. My name is Jennifer Toon, and I am here representing the Statewide Leadership Council today, and I am in favor of this bill. I would like for you to think about your worst mistake, and I'm pretty sure it comes quickly to your mind. And that's testament to how much shame and regret and perhaps hurt that you had caused. Now, I would also like for you to think about the lessons that you learned through that. The difficult process of making amends and the deep spiritual growth. Now I want you to reflect on your accomplishments, your goals, your dreams since that mistake. Perhaps it was a job, a new home, maybe even running for office. Now I want you to take a moment and imagine right before that accomplishment, right before that success, that worst mistake was consistently a barrier. Imagine being defined by your worst mistake for the rest of your life. No matter how much you've grown as a person, no matter how much success you struggle to create. This bill would allow a pathway of redemption for those of us whose mistakes, while legally may be heavier than your own, our desire to overcome them it's no different than yours. Change is possible. I am a living testament that change is possible. But society still denies me, after 25 years, almost 27, housing, employment, opportunities for a mistake I made when I was 15 years old. So I ask you to please support this bill and allow us the opportunities that we dream of. Thank you.
Thank you, Ms. Toon. Members, any questions? We appreciate your testimony today.
Thank you.
The chair calls Kirsten Ricketts. Good morning. If you'll tell us your name, who you represent, and your position on the bill.
Hi, my name is Kirsten Ricketts. I'm the founder and director of Restorer of City Streets. I'm also a member of the Statewide Leadership Council, and I'm an LVN, and I support this bill. I'm for
Okay,
it.
and so you registered to testify that you represent the Restorer of City Streets and yourself. Do we need to add the other, or?
Yes, the SLC, if you will.
Okay, so we will let the record show that you're also representing the Statewide Leadership Council.
Thank you very
Okay,
much.
please continue.
Okay, 10 years ago, I was released from state jail, and I had lost my nursing license because I sold some crack cocaine to an undercover officer. I had a radical transformation while I was incarcerated this last time, and I surrendered my life to Christ. And upon getting out, I established a nonprofit helping women who are coming out of prison, getting off drugs, reestablishing themselves. If you can imagine how hard it is to rent a house just by myself, but to go out and rent a house as a felon to house felons was a really big obstacle to overcome. I know that the things that I have overcome, it has been supernatural intervention in my life to get me to where I am. I got a bachelor's degree in biblical counseling. I'll be graduating in August with a master's in human services with a concentration in criminal justice. And last year I got my nursing license reinstated. So even though all the stuff that I've accomplished, the nursing board still said 2 years stipulations on your nursing license. You cannot give narcotics. You cannot work overtime. You cannot, there was something else. But all these stipulations came attached. So in January, I started applying for jobs. Denied, 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 denied. We don't care what the board said, company policy. We don't hire felons, this. I was going to come tell you today how horrible it was. And then yesterday on my way here, I got a call and I got a job offer.
Yay.
But they offered me $2.50 less an hour than I was making 17 years ago. So that's the strange little caveat that comes with people like me. That no matter what I've done or how prepared I am today to step into these roles, probably better than I ever was in my entire life, and I still cannot make the same wage that I made 17 years ago. So I support this bill, and thank you.
Thank you. Chairman White has a question for you.
Right, and if I could just use that time, thank you, Madam Chair, for bringing this bill and recognize this very, very conscientious lady here. She's from the great county of Polk County. I hope if you go do your nursing job, you will not leave your ministry.
I'm not. I got a job in Trinity, so 40 minutes from the house.
Okay, 40 minutes from the house.
We're staying put.
Right. Thank you so much, and we're extremely proud to represent you and work with you in the Texas legislature.
Oh, thank you, Mr. White.
Any other questions? Thank you for being here today.
County, yeah. Okay. Yeah. Yeah, Blanchard, Texas.
The chair calls Douglas Smith. Good morning, sir.
Good morning, Mr. Chairman, members. Dr. Allen,
Yes.
thank you for bringing this bill. For the record, my name is Doug Smith. I'm the Senior Policy Analyst with Texas Criminal Justice Coalition. I'm for the bill, and I'm also representing the Clean Slate Texas Initiative. And I have one-pagers for you all.
And right now, you're not registered, so do you want us to update that to show that you represent the Clean Slate Initiative? It only shows that you represent the Texas Criminal Justice Coalition and yourself.
Apologies, I wasn't sure if I could double dip on that.
Well, we're
Yes.
going to add to those that you represent the Clean Slate Initiative.
Terrific.
So please proceed.
Wonderful. So again, we support this bill. So first, why? We work with formerly incarcerated people and people with criminal convictions all across the state, people who are showing up as leaders within their community, taking responsibility and creating a better Texas. Some of our members, some of the experiences that they face is that they go 20 years post-conviction, they work hard, they establish careers, and then they move to a different town and can't find a place to live. This is what we're trying to address. We also know that some of our members have to live in substandard housing, and that they just pray that their landlord doesn't get priced out of the market, and then them having to have to scramble again and avoid homelessness. So what this bill does is it creates a pathway for people with more serious convictions to have the opportunity for record sealing. I will emphasize that this is after substantial waiting periods post-discharge. The judge still gets to determine whether it's in the best interest of justice, and the prosecutor has to give consent. I also want to emphasize that those of us who are advocating here today have fought really hard for non-disclosure for folks who do qualify. And we recognize that we're doing that because if we can help those who do qualify, that we ourselves can grow new wings. I'll let you know that this T-shirt that I'm wearing right now, the emblem was drawn by someone in prison. And if you go to the QR code on the one-pager, you'll see a video there, and that was filmed by someone who also has a criminal conviction who has to scramble to find employment, and this is his employment. So thank you so much for considering this bill and a pathway to redemption.
Thank you, Mr. Smith. Members, any questions? We appreciate your testimony. The chair calls Maggie Luna.
Good morning, Chairman, members. Thank you, Grayson. Good morning, Dr. Allen.
Good morning.
I just want to thank you for this bill, which would, excuse me, provide an opportunity, a pathway for someone like me who is formerly incarcerated. In fact, on less than a gram, I did more time than the man who killed somebody. So I've completed my sentence. I've paid my debt to society, and I am here every day fighting for people that are like me, who have changed their lives and become members of society. And, you know, there's many things that I fight for that I will never benefit from, you know, and this is a waiting period, and maybe one day I, like Doug, can grow new wings and be eligible for job opportunities that I've been turned down for. I'm overqualified, but there's a spot on my background. And also housing, subpar housing, which is in the worst neighborhoods. Luckily, I have been able to find someone who independently leased to me. But if I ever have to go anywhere, it is impossible to find somewhere that is not in bad neighborhoods. So I just hope that we get a favorable vote on this, and I appreciate all of you being here every day.
Thank you, Ms. Luna. And before you finish, would you tell us
Yes.
your name, who you represent, and your position on the bill?
My name is Maggie Luna. I represent Texas Criminal Justice Coalition, and I am for the bill, Statewide Leadership Council.
Thank you. Oh, yes,
Yes,
got it.
okay.
Thank you. Any questions? We appreciate your testimony. Thank you.
Thank you.
The chair calls Amelia Casas.
Thank you, Chairman and members. My name is Amelia Casas. I'm here testifying in support of the legislation on behalf of the Texas Fair Defense Project, a member organization of Clean Slate, Texas. I'm here to express our strong support for this legislation, also known as New Wings. This bill seeks to expand record sealing access to many Texans who have completed their sentences but still carry the barriers and burdens of a criminal record. Under New Wings, non-disclosure eligibility would be expanded to include most people who have fully discharged their sentences after a crime-free waiting period of up to 12 years. The length varies depending on the original conviction. This bill seeks to expand non-disclosure eligibility to most convictions. Under current law, only successful completion of deferred adjudication and certain first-time nonviolent misdemeanor convictions are eligible for non-disclosures. However, data from recent years shows that deferred adjudications make up only 24 to 25% of all criminal cases disposed in Texas, whereas convictions make up 45 to 50%. By expanding eligibility beyond just successful completion of deferred adjudication to include successful completion of probation and other convictions from misdemeanor plea agreements, this bill would expand non-disclosure eligibility for countless Texans. The Texas Fair Defense Project recently launched a criminal record clearing program providing direct services to indigent Texans, and I just want to cover some of the things our clients have had to say after finally getting their records clear. One shared, "I can't even tell you how thankful I am to have been given this opportunity. It has been daunting living with a criminal background. This makes me so happy. This opportunity gives me an opportunity to make it in life. Thank you so much." Another shared, "I really appreciate y'all helping me clean up my records so I can go back to work. You have given me a second chance and this old guy will never forget it." 1 in 3 Americans has a criminal record, including millions of Texans. Individuals with records face lifelong barriers to employment, as you've heard. And New Wings offers a second chance to people by expanding record sealing eligibility for countless Texans. I urge you to please support the bill. Thank you very much.
Thank you, ma'am. Members, are there any questions? We appreciate you sharing with us. The chair calls Tracy Walton. And if you'll tell us your name, who you represent, and your position on the bill.
Yes, my name is Tracy Walton, and I am for 3547, I believe. Is that right? Did I get it right?
3547, yes, ma'am.
Okay, perfect. Thank you for your time. First, I want to say that my name is Tracy Walton, and I reside in Montgomery County, and I have for about 30 years. My mother is the longest tenured employee at the district attorney's office. I finally convinced her to quit and live her best life. But I'm here speaking on behalf of my deceased father and my deceased husband. My father died in prison due to being beaten by 5 men. Unfortunately, it was out of camera range. They just knew about it, but there was nothing that was done to anybody. Nobody received charges, nothing. I just got a call because I'm next of kin. I'm the first child, and I got a call that he was on a respirator and if I wanted to see him come now. Unfortunately, he was mentally impaired and not understood by the general population, and that's where he was housed. A group of inmates who misunderstood his mental illness beat him to death. My late husband died as a result of his addiction due to being incarcerated. Once he was released from prison, he was never the same. The light was out of his eyes. He did about 2.5 years in solitaire, and when he came home, he was a different person. And I needed a father for our son. We had a son together. Unfortunately, now I am dealing with my son's continuing and worsening addiction. My late husband, I do want to go back to that really fast. Due to being incarcerated and upon his release, he wasn't able to gain employment. He was like, I'm not going to work at Burger King. He said, I deserve more than this. I have my education, but unfortunately, he didn't put enough into the Social Security system to leave me any benefits as he was 24 years old. I had to obtain student loans to pay for a funeral at 24 years old. I mean, we weren't thinking of life insurance at that time. I met a group of people who introduced me to the New Wings program, and they have given me this opportunity to tell my story here today. I'm trying to save my son's life. Being, overdosing and going to the hospital, being brought into the family room, asking, would you like your son to be cremated? Would you like him to be, burial? These are questions I shouldn't be asked. No mother should be. I was an enabler in 2013. I am no longer an enabler now.
Thank you, Ms. Walton. And just so that the record is clear, it shows that you represent the SLC and yourself. Is that accurate?
Yes.
Okay, and then can we update that so SLC stands for Statewide Leadership Council? Is that okay?
Yes, sir.
We just want to make sure everything's clear.
Of course.
And we appreciate you sharing very personal information with us. I know you've heard others testify. Hats off to you for coming this far and taking the time to tell us. Members, do you happen to have any questions? Thank you for being here today. We appreciate it.
Thank you very much.
The chair calls Coretta Brown. Good morning. If you'll tell us your name and who you represent and your position on the bill.
Good morning. My name is Coretta Brown. I represent Texas Organizing Project as well as myself, the Alliance for a New Justice System. And we stand in support of House Bill 3547, New Wings. Thank you, Representative Alma Allen, for following this bill. I heard the witness that just left. She said that her husband didn't want to work at Burger King. In 2008, I got hired at Jack in the Box corporate. And I worked like my butt off at 725 until I became a team lead. And when I became a team lead, I worked my butt off because I wanted to be an assistant manager. One of my goals in life has always been to be a restaurant owner. I did so well that the general manager applied for me to be an assistant manager. I got denied because of my background. Not only did I get denied, but they threatened to take my team lead position away from me, which I had to go and get legal help because that would have been a violation of a law that had already given it to me without looking at my background. So they judged me initially based on my work ethics and on who I was as a person. My background didn't have an issue at that time. But then when it became time for me to get better benefits, make more money, have more responsibilities and things like that, which I was already doing it. I was already doing the paperwork and stuff like that. They said that it was going to be like a liability on the company because of my background. So like giving and expanding non-disclosures, and we're just talking about misdemeanors right now, it's going to help a lot of people become better citizens, become better taxpayers, and just all around help our community. So that's why we stand in support.
Thank you, Ms. Brown. I really appreciate you sharing that with us. Members, do you have any questions? I will tell you that just trying to sit here and visualize those experiences that you have overcome, it makes all of us want to be a better person because we kind of look to you as an example. So don't overlook the fact that adversity brings you to the challenge and helps you climb that mountain. So thank you for being here.
Thank you.
We don't show anyone else that's registered to testify today. Is there anyone else who wishes to testify on, for, or against House Bill 3547? Seeing none, the chair recognizes Dr. Allen to close.
Mr. Chair and members, I hope hearing the testimony of these persons who have spoken today makes you aware that every sentence in Texas is a life sentence. And so we can grant them release by passing House Bill 3547. I close. Thank you.
Members, are there any questions? And without objection, House Bill 3547 will be left pending. cognizant of the fact that we will have to take a break before 10 a.m., I'm going to go ahead. The chair lays out House Bill 358 and recognizes Representative Sherman to explain the bill.
Thank you, Chairman Murr, Vice Chair Allen. In my conclusion, technical violations are not by themselves criminal offenses and generally do not result in rearrest. However, they can result in re-imprisonment. Revocations for technical violations of community supervision cost the state nearly $70 million in order to house individuals in TDCJ facilities. Mr. Chairman, this bill also passed out of this committee unanimously last session, and I want to thank you again. I reserve my right to close.
Members, are there any questions? Recognizing that, we will call our first witness. The chair calls Paige Williams. Good morning, and if you'll tell us your name, who you represent, and your position on the bill, please.
Good morning. My name is Paige Williams. I am in support of House Bill 358. I represent the Dallas County Criminal District Attorney's Office. Because we are looking at a 10, I will be brief. For many of y'all already know that the technical violations include things such as avoiding individuals who are interest behaviors, persons of disreputable character, things, as Representative Sherman said, were not criminal in and of themselves. Our office is in support of this because prisons are not meant for an individual who is just violating things that are not crimes. It is meant for those who are a threat to our community, and that is how it should be utilized. The bill would stop that revolving door of the individuals who are just making poor mistakes on probation, and keep our prisons for those who are actually committing crimes.
Thank you, Ms. Williams. That's very concise and direct.
Thank you.
Members, any questions? We appreciate you taking the time to be here. Please tell Mr. Creusot hello for us.
Thank you.
All right. The chair calls Molly Westfall. Judge Westfall. And just like last time, if you'll tell us your name, who you represent, and your position on the bill.
I'm Molly Westfall. I'm judge of the 371st District Court. I represent myself. I'm testifying against the bill reluctantly. We had a lot of good meetings with Representative Sherman during the last session. I think that really has not been an option to continue those conversations because of the current conditions for this session. But I would point out that the bill limits judicial discretion. It limits it in a way that isn't necessarily obvious from reading the bill, but from being in practice for 25 years, I can tell you that there are a number of very serious offenses that are third-degree felonies. Assault on a family member with a prior conviction, injury to a child causing bodily injury, assault on a family member by impeding breathing. The last time I looked at our pending caseload in Tarrant County to see how many family violence cases we have, because I have a special program that deals with those felony cases, 10% of our cases, like 2,300 cases, felony family violence cases that are pending in Tarrant County. So this would be a lot of offenses that would be covered by this technical revocation issue. And when you say technical revocation, immediately people think of non-payment of fees, failure to report, being late for a report. There are a number of things that are technical violations of probation that are actually community safety issues. If you have someone on a GPS and they cut that GPS off so that you can't monitor them anymore to see if they're staying out of exclusion zones, that's a technical violation of their probation. Someone who's on probation for an injury to a child. I spent 4 years prosecuting child abuse cases. I keep forgetting to take this thing off. I feel like I'm getting undressed every time I take it off. I spent 4 years prosecuting child abuse cases in the DA's office. Sometimes when we had difficult cases that we couldn't proceed on the sexual abuse allegation, we would plead them to an injury to a child. And we'd say, but you're going to have to do sex offender treatment. If someone was pled to an injury to a child, third-degree felony, and said, I'm not going to do sex offender treatment, that would be a technical violation of their probation. And that would fall under this bill, even as a single allegation. So I want you to consider that even though I agree with what you're trying to do, this bill really limits cases at the extremes that are community safety issues and are third-degree felonies. And some of those technical violations, they really deserve our attention from the get-go.
Thank you, Judge.
Yes.
Members, are there any questions? We appreciate your time here today. Thank you for sharing with us.
Certainly.
The chair calls Jorge Renaud. And then next on deck will be Devin Driver, just FYI.
Thank you for allowing me to speak on this, Chairman. My name is Jorge Renaud. I'm Southwest Region Director for Policy and Advocacy, Latino Justice, and I'll be quick. In Texas, they have this great saying that talks about if the only tool you have is a hammer, everything's a nail. You know, and the only option is to beat the hell out of it. And that's pretty analogous to what the supervisory agencies in Texas, as the tools that they have when it comes to what is called a status offense. How you deal with a status offense in Texas, right? These are offenses that only apply to individuals who are on supervision, right? And the thing is, you can be, and you are often reincarcerated for that, despite whatever they say that we don't hear it, it doesn't happen in our jurisdiction, whatever. The fact is that there are thousands of people in TDCJ right now who are there because they have been convicted of a status offense, right? Now, here's the thing. I understand that there are some technical violations that also maybe fall under the category of a crime, that if they do, if that is so, then I think it is incumbent upon district attorneys and judges and whatever to actually prosecute those as crimes and not send an individual back to prison for something that is just a status offense. You were judged for 5 years, and you understand very much about discretion, about how maybe sometimes your hands were tied behind one statute or another. And I think that what this does is that a lot of times probation departments and the parole and parole in Texas, their hands are tied by statute. What this does, it gives individuals more tools. It gives judges more tools to say, this individual does not need to be punished further. They don't need to be reincarcerated. They need to be supported more and reintegrated back into the community with more assistance. That's all I have to say, and I hope that you will support this piece of legislation.
Thank you, Mr. Renaud. And just to be clear, your position on the bill.
This is, I'm sorry, in support of.
In support.
For,
Thank
yes,
you
sir.
very much.
Okay.
The chair calls Devin Driver. And that is the last person that we showed that is registered. So if anyone does wish to testify, please be registered and ready to go. If you'll state your name, who you represent, and your position on the bill for us.
Awesome. Good morning, y'all. My name is Devin Driver. I'm a policy analyst for the Texas Criminal Justice Coalition, and I am in support of this bill. I promise to keep this as short as possible, but this bill is extremely important because it allows us to look at every single option before we reincarcerate someone. As all the witnesses before me have stated, locking someone up when they are violating probation technically isn't really the answer. We did probation research at TCJC over the last few months, and we went into different counties and we spoke with people, and they said, we don't like to revoke for technical violations, and we try not to. But to wake someone up, sometimes we do. But it's not up to them whether that revocation ends and actually being revocated. So this takes that step out of there. This allows for probation departments to really work with individuals that are on probation and establish that continuity of care and say, hey, we don't want to send you to jail. We really need to talk about this. We really need to see what is working, what's not. It really employs that conversation. And so that's why I'm in support of this bill. Please let me know if you have any questions.
Thank you very much, members. Are there any questions? We appreciate your testimony.
Thank you.
We don't show that anyone else is registered to testify. We do have some resource witnesses. If anyone does have less than 4 minutes of questions for them, happy to call them up. Is there anyone else who is wishing to testify on, for, or against House Bill 358? Seeing none, the chair recognizes Representative Sherman to close.
Thank you again, Chairman Murr, Vice Chair Allen. Technical revocations are the reason for over 50% of the revocations of probationers and 17% of parolees. This causes more offenders to have their probation or parole revoked, thereby increasing recidivism rates. The felony probation revocation rate has remained unchanged for more than a decade, and the proportion of the overall revocations that are for technical violations has increased. Conversely, the TDCJ Parole Division has implemented policies that have led to a 50% reduction in parole revocations, and only 10% of these revocations are for technical violations. Felony probation revocations account for nearly 1/3 of all new receives into the TDCJ system each year. The number of people revoked and sent to prison is disproportionate for individuals who suffer and struggle with substance abuse and addiction. Committee, you know, when we look at reform, often we hear judges say, you're taking away our discretion. And the problem is not with honorable judges like Westfall and many others. We have 254 counties, and this is about establishing a system. It's the same when we look at police reform. Often, police officers say, we don't have a problem with this. We don't arrest people for not turning on their signal lights. But yet more than 64,000 Texans lose their liberties and freedoms because an officer arrests them for not turning on their signal light. So with the 2 minutes in closing, I implore you, this is not for those that follow discretion. This is for those who don't have the judgment and are sending those thousands of people back to prison, and they're losing their liberties. Thank you. With that, Chairman, I move to close.
Members, if there's no objection, House Bill 358 will be left pending. Members, we are approaching the 10 a.m. time period, so it looks like we've got to head to the House floor. Without objection, the committee will recess until the final adjournment or recess of the House today or during the period authorized for reading and referral of bills if permission is granted by the House. The time is 9:58.